Welcome, everyone, to our webinar on planning your exit, tax and legal essentials for startups. My name is Bianca Reynolds. I'm a practice leader in the corporate team at LegalVision, and my co-host is Jack G, a partner at William Buck. So before we begin, a couple of quick housekeeping items. So you'll receive the recording and the slides in your email. Please submit your questions in the Q&A box and we'll go through them at the end of the webinar. And we'd also appreciate it if you could complete this feedback survey after the webinar as well. And for the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. So please provide your contact details in the survey at the end of this webinar. We also have a poll question that you might be seeing coming through now. So if you were to exit your business, what time frame is likely? It'd be great to hear from you all as to an indication of your plans for the future. So while you come through and continue to put in those answers, we'll just move through to the agenda for the day. So today in our webinar, we're going to be discussing structuring your exit, tax rollovers, earnouts, and other concessions, managing legal risks, including the required documentation for the exit, and also preparing for sales. So things like seller due diligence, getting ready, and actions you should take. And now I'll hand over to Jack, who's going to speak about structuring your exit from a tax perspective first.
Thanks, Bianca. Hello, everyone. I'm a partner at accounting firm William Buck. I do a lot of work with tech startups and scale-ups on the accounting, tax, and advisory needs from startup to exit. And today's focus is obviously on how to maximize value for shareholders in an exit. So this is, of course, key given the amount of hard work that goes into making a startup successful. For founders, the day that their startup gets acquired can be bittersweet. A successful exit will be a huge validation of what the whole team has built and achieved over the years. Now, there are a number of commercial, legal, and tax considerations which directly impact on the ability to get the deal done, how smooth the sale process is, and ultimately how much value the shareholders are able to extract from the deal. Our goal today is to help you get an overview of these considerations. Now, as always, this is not tax advice. So please ensure that tailored tax advice is sought for part of any deal. Now, in terms of tax, since tax is applied as a percentage of any gain, it can quickly add up to a very large number. Therefore, it is critical that sufficient time and attention is applied to tax planning. It is not an exaggeration to say that no exit can be truly successful if shareholders lose a bigger than necessary chunk of their wealth to the tax office. Now, you have to pay a tax, but only up to the point where you're obligated. One of the key things to get right is ensuring that the shareholder is the right type of entity. Why is that relevant? The 50% capital gains tax discount. Only individuals and trusts are eligible for the 50% CGT discount. So if it's a share sale, then you want to have an individual or trust to be the selling entity. So this is the very basics.
Wonderful. Thanks, Jack. So now just wanted to come back to our poll question. So in terms of the responses, so it looks like the majority of you are, just exploring some options, don't have any immediate plans to exit. But a lot of you are also thinking about exiting within the next 2 to 3 years. So, that's great that you're really thinking early on about how you can plan for this process, learn a few things and get some knowledge to help you as you move forward.
Yeah, that's a good time
Fantastic.
frame. Yeah, good time
Yeah,
frame to start thinking about this.
yeah, absolutely. So from a legal perspective, it's really important to obtain the right legal and, of course, tax advice, when you're preparing for the sale, but then figuring out what structure is going to be best for you. So There are two main ways that you can generally go about conducting an exit and the sale of your business. So, as Jack was talking about, you can sell the shares in your company if you operate through a company structure, or sell the assets which comprise the business, which are actually owned by your company. So in order to decide what structure is right for you, you have to think about, timing, what kind of transfer requirements, what kind of consents or approvals you might need to obtain, particularly if you have licenses in place in your industry that might not be capable of being transferred. So these are all things that you need to be thinking about. And the tax implications, of course, will have a big part to play in that as well. So in terms of the share sale approach, in this type of transaction, the buyer normally acquires the whole company. So all clients, suppliers, employment contracts all stay with your company. So there's less effort in the sense of obtaining required consents to actually transfer any of those things over to the buyer because they stay with the company. And as Jack was saying, this can also have some tax advantages depending on how you actually hold your shares in the company. But some of the cons to think about are, if the buyer is acquiring the whole company, then it means they inherit all of the historical liabilities, all of the skeletons in the closet. So to protect against that, they may ask you to provide fairly extensive warranties, which could be for an extended period of time. And depending on the shareholders, that liability could extend to you personally if you hold your shares as an individual. They might also ask you to provide a guarantee, again, to protect the buyer. If there's a breach of warranty, then they could come after you personally as well. And there'll also more likely be a more involved due diligence process because of the risks that the buyer is taking on in a share sale transaction. So an asset sale in this type of transaction, the buyer is really acquiring certain assets rather than the company as a whole. So, you'll likely be required to provide fewer warranties and indemnities when compared to a share sale. You can also agree with the buyer to exclude certain assets that are not going to be transferred over to them. So that could be beneficial for both you and the buyer as well. So some of the cons to think about though are that because everything is actually being transferred from you to the buyer, the transfer of each of the contracts and the assets being purchased may require the consent of third parties, and that can be a time-consuming process. If you have equipment that's subject to finance, for example, or equipment hire arrangements, you might need to obtain releases of any security interests. The same goes for if you have a business loan with a bank, for example. And in an asset sale, a lot of the liabilities will generally remain with the seller, so remain with your company, which means that if you then want to wind up the company after the sale, there's an additional process that needs to go through in order to do that. Fantastic. So we'll just move on now to discussing tax rollovers, earnouts, and other concessions. So I'll just mention this from a legal perspective as well, but I'll just hand back to Jack now to go through some of the tax implications.
Thanks, Bianca. Now, we've spoken about the 50% CGT discount, and there are also a number of other tax concessions available, which could make a major difference on either the amount or the timing or both of the tax paid in an exit. So, and each have their own eligibility requirements. Firstly, because we are talking about startups and scale-ups, there is the early stage innovation company or ESIC tax incentives for non-founder shareholders. So by that, I mean typically the external investors. One of the policy intent of these ESIC rules is that it's trying to help founders raise capital from external investors. And as a result, the ESIC rules are not intended for founders to benefit, generally speaking. Okay. So as far as the ESIC is concerned, it's a really attractive tax incentive because not only do eligible investors receive a 20% tax rebate for the amount they invested for the relevant income year when they did invest, but also capital gains that they make from years 1 to 10 are exempt for capital gains tax. So as you can see, this is a really powerful incentive when the fact pattern stack up. And because the sky's the limit as far as the capital gains concerned from a tech company. So, however, ESIC rules are complex and eligibility evidence needs to be kept from day one. The tax office are very big on documentation. So there might be very little attention paid to it, in the beginning. But when there are big dollars at stake, then documentation proving eligibility will be critical. And you only get one shot at keeping the evidence a lot of the time. So definitely focus on documentation and getting the right advice. So that's the ESIC. Now, where part or all the consideration for the sales shares in a company, usually in the acquirer itself, as Bianca has mentioned, this is commonly known as a scrip deal. So the scrip for scrip tax rollover becomes critical in order to defer the tax liability. Otherwise, the shareholders are left with a tax bill whilst they're holding what is usually an illiquid asset with no means of servicing that tax bill. So you don't want that. And the scrip for scrip tax rollover will be key. Where part of the sale consideration is an earnout, it is important to structure the earnout as what's known as a look-through earnout right to once again access a deferral of tax liabilities. If it's not structured correctly, basically the tax law and the tax office would treat the earnout as essentially taxable in the year of receipt, even though the actual earnout payment has yet to be made. So once again, this needs to be structured properly at the time the deal is negotiated. Okay. And finally, there is a small business capital gains tax concession, which is an extremely powerful way to reduce part or all of a tax bill, depending on your eligibility. Now, the small business CGT concession is typically more relevant for what I call traditional businesses, where the number of owners are usually limited. Where there are a lot of shareholders, eligibility can suffer, but just bear in mind that this thing is there, and needs to be considered, or at least just simply ruled out.
Wonderful. Thanks, Jack. So I guess just touching on a couple of the legal points that Jack was mentioning there in terms of how you might structure the consideration. So when we're talking about things like an earnout arrangement, from a legal perspective, in general terms, it's really just, a pricing structure where a portion of the purchase price is earned by the seller over time, based on the performance of the business after the buyer has taken over. So as well as thinking about the different tax concessions and issues that are relevant, you also need to think about how you're going to structure the, criteria for the earnout. So thinking about what performance milestones that, might be contingent on certain timeframes, when these are reached, how are they going to be assessed in terms of KPIs, things like that? How are you going to retain a certain level of control over the business to make sure that you can actually meet the earnout requirements? So you just really need to be really clear with the buyer on the framework for that process, including, certain things around the buyer providing you with reports on the status of the business and its revenue over time. And essentially, in terms of the scrip for scrip, really just talking about a share swap. So, you'd be exchanging your shares in your company for shares in the buyer entity. So, from a legal perspective, it's important to think about things like what class of shares you're going to receive in the buyer entity, what rights does that share class entitle you to, what are the terms of any shareholders agreement and constitution that the buyer has in place. And also, how are you going to actually be able to verify the value of the shares that you're receiving in the buyer? So, just a few additional things to think about there when structuring the consideration for the exit as well. Okay, so now we'll discuss managing the legal risks and some of the legal documentation you can put in place to assist you with this process. So, the first type of document that you will come across and may already be familiar with are non disclosure agreements, also called confidentiality agreements. And they're important to enter into with the buyer as early on in the discussions as possible, and certainly before the due diligence process gets underway. So, it will help to protect your sensitive business information before you start disclosing it and before negotiations begin. So, the next type of document you'll likely come across is called a heads of agreement or a term sheet. Might have other names such as a memorandum of understanding. But really, this document is intended to set out the key commercial terms of the transaction before you and the buyer proceed to drafting the legally binding sale agreement. So the purpose of this document is so that you and the buyer can agree on those fundamental terms, things like the purchase price that's going to be payable, so that no one wastes any time or money in trying to get through a deal that has major commercial issues that haven't been resolved up front. Okay, so the next type of document you'll come across will be the sale and purchase agreement. So if it's a share sale, it will be a share sale agreement. If it's a business sale, it's going to be business sale agreement or asset sale agreement. And this is really the primary transaction document which sets out the terms of the sale. So the price and obligations on the parties, key clauses such as any conditions precedent, which are, I guess, key tasks that have to be satisfied in order for the deal to go ahead, obligations on completion, warranties and indemnities, and any post completion obligations as well. So it's important, to minimize your risk exposure in the sale agreement by including things like any kind of caps and limitations on indemnities and your liability for any warranties that you're providing. Also having a time limit on the buyer being able to make a claim against you for breach of warranties, and any kind of minimum claim thresholds as well will be really helpful for you. So, if the transaction is structured as an asset sale, there are some other key documents to think about too. So, ensuring that if you need to transfer any intellectual property rights, what does that look like? Do you have a license to use certain rights that you then need to transfer over to the buyer? Making sure you're reviewing your key contracts for things like your clients, customers, suppliers. From an employment law perspective, making sure that the arrangements with your employees comply with employment law, their employment contracts, any awards that are relevant to them. So making sure that you understand what entitlements that they're entitled to, and then how those can then be transferred over to the buyer as well. And finally, if you operate a premises-based business, really important to consider the terms of your premises lease. Can it be transferred to the buyer, or is a new lease going to be required? So, in both types of transactions, some other key legal issues to think about are any regulatory and compliance risks. So, ensuring the activities of your business meet, and any industry regulations that apply. Do you need approvals under your own company's governing documents? So, if you have a shareholders agreement, do you need approvals at shareholder level and board level, or just board level? How are you going to resolve any disputes with the buyer? So it's important that those kind of mechanisms are considered and then put into the sale agreement. And finally, any kind of post-sale obligations. So, particularly if there is an earnout, do you have any ongoing duties? Are you going to be providing any kind of consultancy support to the buyer or working in the business for a
Mm.
period of time after the transition? So really important to kind of have a think about all of those things as you start preparing and planning for your exit. So I'll now hand back to Jack to talk about a few other things you can do from a tax perspective for preparing for sale.
Thanks, Bianca. As Bianca has discussed, there are two major ways, being share sale or asset sale. Now, from a tax standpoint, there are clear tax benefits a lot of the time to shareholders when it is a share sale as opposed to an asset sale. Most of the time, essentially, shareholders miss out on the ability to halve their tax, right? So not all the time, but very often it is like this. So typically there is a tension between what the seller wants to do, sell shares, versus what the buyer wants to do, which is just only take the bits they like, to buy just the business assets. Now, most of the time it is done as a share sale because ultimately the buyer is able to get comfort on some of the risks using the mechanisms that Bianca has discussed. But essentially, you want to, as the shareholder, as the founder, make the company as attractive as possible. So in order to facilitate this, you need to ensure that the company is exit ready. Okay, so the buyer will usually closely examine the company with the help of a team of lawyers and accountants to find any skeletons in the closet from a tax, commercial, and legal standpoint. And in a share sale, it is usually the seller that ends up being exposed to historical tax risks as a result of tax warranties, which can be very complex and technical in the share purchase agreement, share sale agreement. And these warranties will always require a detailed review by a tax expert, these tax warranties, to ensure that you're not on the hook for anything you shouldn't be exposed to. In the due diligence process, it is highly likely that any past tax issues will be exposed. Okay, and these will often end up being a sticking point that could result in adjustments and reductions in the sale price. And in rare situations, you might actually even kill off the deal, but those are rare. There is rarely a quick fix to these historical tax problems. Therefore, with the companies we work with, to maximize shareholder value, we treat the exit as a years-long process, whereby the best practice is put in place well in advance by looking at the following issues as soon as possible. Number one, I'll advise companies to spin out non-core businesses or assets in a tax-effective manner, thereby increasing the likelihood of the buyer taking the company instead of just some select assets. Some examples of this is if there's more than one business and the buyer is unlikely to want both businesses, well, then don't have it in the same structure. Okay, there might be various private loans in the business as well. A bit less common when it comes to tech startups and scale-ups, but it does happen. Get rid of those things that don't need to be there. Okay, so spin out non-core businesses or assets. Secondly, conversely, you may need to consolidate assets under a common ownership structure if they're currently sitting under disparate ownership structures. This is quite common. For various historical reasons, they may be sitting under different companies, not even in the same ownership chain. If they're sitting under different companies within the same ownership chain, that might not be a problem. So when these assets are moved around, once again, you need to ensure that the movements must be done in a way that doesn't cause unnecessary tax liabilities. So there may be a bit of an exercise there. Thirdly, I advise people to design employee share schemes that facilitate rather than hinder an exit by locking in key staff and at the same time, making it easy for employees to get some value out of a sale alongside the shareholders. So this is quite important. So, a lot of deals will require key employees to stay in place for a set number of time. And employee share scheme, the same way that it's kept them retained and motivated before the sale, it could keep them retained and motivated after the sale for the period that you like. Next, minimize employee versus contractor risk. This is very often a big one. So this is an evolving landscape, this is quite a legal question. So certainly seek legal advice from LegalVision if you like. But basically, hidden payroll tax and superannuation obligations can arise when people get it wrong, and the additional liability can get very big very quickly. And once again, this is a big enough issue that can scuttle the deal or result in a pretty significant reduction in the sale price if something goes wrong. Okay. One common example, besides the usual, are these people contractors or employees, is have the employee share option plan been included in the payroll tax returns? So this is something that I see that gets missed all the time for companies that are above the payroll tax threshold. And once again, the amounts can get pretty big. And next, an issue that's often forgotten is there are various overseas digital tax and sales tax obligations. Now, if you've got a lot of customers in overseas jurisdictions, especially certain American states, definitely keep an eye out for something like this. And, it could come up. It could definitely come up. It's not high on people's radar, but it definitely, in theory, has an exposure. And finally, ensure compliance with the R&D tax incentive, because a lot of startups and scale-ups, when they get acquired, they may not even have break even, or maybe they have break even, but they're utilizing carry forward tax losses. So really the single biggest income tax issue, as opposed to employment taxes or sales tax, the single biggest income tax issue for a lot of these startups and scale-ups is the R&D tax incentive. Now, this is a very technical area, and people often get pretty key questions wrong. And when that happens, the amounts at stake can be very, very big. So you want to make sure that the R&D tax incentive is done properly and the correct documentation as required by ATO and Aus Industry are being kept. Okay. So the common thread here, the need to start the tax planning process now, years before an actual exit. And so, which is actually why I said it's good that it seems that a majority of those in attendance today, they picked 2 to 3 years as a potential exit. So you're in the driver's seat if you use the time wisely. So this will make a big difference to how smoothly the transaction plays out, and ultimately whether founders and shareholders receive what the business is truly worth. I'll go through an exit ready exercise with the companies I work with, and I'll be happy to offer a complimentary session for those in attendance today if you're planning a sale in the coming year or two. So over to you, Bianca.
Great. Thank you, Jack. So yeah, Jack's gone through a lot of points to consider, from a tax perspective, but also touching on some of the legal issues there as well. So I think, once you've kind of thought through all of those points, it's good to start getting your business in order from a legal perspective too, particularly so that you're ready for the due diligence process. So, having a think about what the strengths and your weaknesses of your business are and addressing them early on is really important. So it's best to start this process by doing an audit of the documentation you have in place in your business to understand where there are some gaps that you need to address. So financial information, of course, making sure that your financial statements and key financial records are up to date, accurate, and complete. Employment contracts, you should be having signed and compliant employment contracts in place. For customer and supplier contracts, Again, best to have written customer and supplier client contracts in place, particularly with your material customers. So if you generally only have, handshake or more informal agreements in place, this could actually devalue your business as there'll be limited value that you can actually transfer across to an incoming buyer in the sense of an asset sale. Um, and also in the sense of a share sale in terms of what is your business locked in? What terms does it have that are secure that the buyer can rely on if they take over the company? So having a think about your intellectual property as well is also really important. Do you have a registered business name or a trademark in place? Do you have social media accounts, domain names, ownership of any source code you've used in your business? Important to think through those points as well, including who actually has ownership of those rights. As I mentioned earlier on in the webinar, having a think about any industry licenses that you have in place is really important as well. For example, NDIS registration is not something that can be transferred, and you do need to notify the NDIS of a transaction. So, really understanding your particular business, your industry, and whether there are any notification or consent requirements from any government or regulatory bodies that you need to obtain in the process. It's best to understand those early on so that you can work with the relevant timeframes they provide to you. From a more practical point of view, it's good to have a think about what plant and equipment you have in your business. Is anything subject to finance? How are you going to deal with paying out any finance if a buyer wants to take over those assets? Is the items of plant and equipment in good working order for their age? Do you need to start putting in place a maintenance and repair schedule to ensure that they are going to be valuable assets capable of being used by the buyer? And then finally, having a think about your premises lease. Again, if you're a premises-based business, but you actually have a formal lease contract in place, does it have sufficient term remaining or any options to renew to ensure that it is an attractive lease for the buyer? So these are all kind of questions to start thinking about and address, as you start planning for that next steps in your exit and the transaction process. So that really concludes the main part of our webinar today. You might find our startup manual useful, so please go ahead and download that using the QR code on the screen now. You might also find our next webinar interesting as well. So that's going to be the new wage theft laws, what employers need to know. So of course, very relevant if you have employees in your business or you're growing and you're looking to bring on employees in the next little while. So here are some contact details for Jack as well. As Jack mentioned, happy to have that complimentary consult with you to plan your exit ready process. So please reach out to Jack using these details if you'd like to take him up on that offer. And finally, just wanted to talk a little bit about membership while you send through your questions in the Q&A box. So by becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all of your business as usual legal needs. So it's really like having your own in-house legal counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviews of business contracts. We can help with unlimited legal advice consultations and also unlimited domestic trademark registrations. If you don't yet have a trademark, definitely something to be thinking about to help, increase the value of your business as you plan for that exit. And really, as a member, you don't have to worry about the cost of lawyers moving forward. We take care of all of your business as usual legal work so you can focus on running your business. And if you do happen to be any in-house counsel, we also offer a dedicated service to help you with managing your high volume business as usual tasks as well. So to learn more about our membership, please request that free consultation when the survey appears at the end of the webinar. And now we'll go ahead and answer some of your questions. So Jack and I will just start looking through those now.
Mm.
Um,
I've already answered. Thanks, Bianca. I've
yeah.
I've answered some of the questions already. Furiously typing. Hope people find that useful. Yeah. So everyone can see the Q&A box, can't you? Yeah. Okay.
Mhm.
Cool. All right. So sorry to jump in. Back to you,
No,
Bianca.
yeah, no problem at all. So I think we've had a couple coming through as well. Um, oh, Jack, I was just going to mention that one. So any common R&D tax incentive mistakes? I'm not sure if that's one maybe you would like to speak to.
Yep.
Completely up to you.
Yep. I'm very happy to. I've just answered that with where do I even start? And also included a link to an article we wrote on some of the most common mistakes. So if I were to just rattle off what comes to mind is the most common mistakes are a lack of records being kept on the timesheet side of things. You might say, oh, my CTO spent 80% of his or her time on R&D. Well, where's the records? That's the only thing the ATO cares about. These are government, people we're talking about, and documentation is big for them. Okay. Another common mistake we see is the R&D experimentation process is inadequate. You cannot prove that there was a good hypothesis that satisfies the requirements, and you cannot show that there was an experimentation process, in which case the whole R&D claim can unravel. And this is where having a really solid R&D claim in the first place is incredibly important. Other common mistakes I see is, for example, where there's related party expenses. ATO is highly sensitive to this area, as you can imagine. It doesn't want people to shuffle bits of paper and then all of a sudden find an R&D claim. So where there are related party sort of expenses, got to be really careful. And also tax consolidation, where not the right entity got registered. So I don't want to turn this into a huge discussion on the R&D tax incentive, because that's not what today's topic is. So feel free to have a look at the link that I sent.
Fantastic. Thanks, Jack. So just seeing a few more questions coming through now. So particular question about, I suppose, how more generally a contractor can own equity in the company when they're based overseas. I mean, generally speaking, in Australia, it's perfectly fine to have foreign shareholders. There's no particular issue with that. The concern, I suppose, is maybe more of a tax question for the relevant entity that's investing in your company, if your company is based in Australia, in terms of their local foreign tax laws, and also whether they have any restrictions in their foreign jurisdiction as to them actually owning equity internationally, is something more so for the contractor that they would need to consider as well. Yeah, Jack, I don't know if you had anything to add to
That's
that
exactly
point.
right. Essentially, that overseas employee or contractor need to seek their own tax advice relating to their jurisdiction, because what works in Australia may not necessarily work for them. Usually, it's not a showstopper. Usually, there is some kind of a solution. You just need to cater for them. For example, in the US, there are various tax concessions and shortcuts. One of them being what's known as the 409A valuation, which usually ends up with a concessional result for tax purposes for employee receiving equity. So just bear in mind that it is an overseas tax issue. Have it considered from their angle.
Yeah, yeah, great. Okay, so just another one coming through. What kind of approvals do you normally need internally to sell shares or business assets. So this is really going to be dependent on the terms of your relevant shareholders agreement. So, most of our startup clients do have a shareholders agreement in place, and certainly if you don't have one in place, we would absolutely recommend you have a chat with us to help prepare one for you. But generally, it can be quite common for shareholders to be required to approve a particular type of exit event. Often, what you'll see in shareholders' agreements are what we call drag along and tag along clauses. So that, if you have minority shareholders and you have a buyer that's come along, they want to acquire all of the shares in your company. Um, if you own at least a certain percentage of those shares, quite commonly is at least 75% of the shares, then you can actually look to drag any minority shareholders along with the sale to effectively help make the exit process a lot easier, a lot smoother, so that you're not having to deal with getting that kind of consent and getting different input from, minority shareholders in that type of situation. Um, Perfect. So just one other question that I suppose is a fairly general question that we can look at answering as well. So if you're doing a business sale, what happens to your company afterwards? So really it depends on what you're planning to do following the exit of your business. So if it is structured as a business sale or an asset sale, transferring the assets over to the buyer, then you will retain that company. So you can either do something, start a new business with it, do something quite different, or you can actually go through a voluntary deregistration process. So it's a fairly straightforward process, but there are certain conditions that have to be met for a company to actually look at winding up. And certainly, if there are any kind of deferred payments, any earnout arrangements, anything like that, then you absolutely want to make sure that your company is not deregistered until you receive the full payments that you're owed under the sale agreement. But generally, going through a deregistration process just means that you need to get all shareholder approval. The company also needs to have assets that are, I think, less than $1,000, no outstanding liabilities. And once those criteria are met, it can then submit an application to ASIC to voluntarily deregister and wind up, and then it will cease to exist once that process has been completed.
There's another question from Angus.
Okay.
Is it okay to accelerate vesting for option holders at the time of exit? Was this generally negative perception from the buyers? I don't see any issues with that whatsoever. I think it's positive because you're sharing the wealth with employees. Obviously it does mean that, the sale process, there's an additional moving part. And I'll get Bianca to comment on that. But from a commercial standpoint, I see this quite commonly, and I see that it's a good thing. You're sharing wealth with employees.
Yeah, absolutely. And that is something that we do see quite common from a legal perspective as well. So essentially, because as Jack mentioned, you're recognizing that if they've been working in the business for a period of time, they've contributed to that growth, so should be entitled to participate in the benefits of that. I guess one thing to think about is if you do have more recent employees coming on board, whether you do want to allow effectively all employees to have their options accelerate on a vesting, or whether it's something that, if they've been working for a certain period of time in the business, then you'll accelerate the vesting. It's generally, of course, more, I guess, balanced and favorable if all employees get accelerated vesting on an exit. But it can be tailored to your specific circumstances and what makes sense for your business.
Thanks, Bianca. Got a question. Is it okay if there's non-Australian entities that are shareholders? Pretty common. I don't see it as an issue. Bianca has already mentioned the drag along rights as part of the shareholders agreement. That is something that would be taking this issue into account. Okay.
Okay.
Just reading some of the other questions.
Yeah. Great. So it looks like we've got a question come through of asking a bit more about why issuing options instead of shares that vest over time subject to KPIs. I mean, you certainly can do it either way. The benefit to issuing options is that the individual does not become a shareholder straight away. If someone becomes a shareholder, they then have rights as a shareholder, which depend on the class of shares that they hold. So while their shares may still be subject to vesting and have certain restrictions placed on them, they do generally still have the right to vote as a shareholder and participate in certain shareholder decisions at law and under your relevant shareholders agreement. It's also a lot more difficult to buy back and cancel shares than it is options. There's quite a, I guess, burdensome process under the Corporations Act that has to be followed whenever you want to buy back shares. So if an employee leaves and they are also a shareholder, that can just be a bit more of a difficult process to go through, as you need all shareholders to approve the company buying back shares, generally speaking. And you need to submit certain forms to ASIC, provide certain information to shareholders. So it's just a more difficult process in general, whereas options, much easier to just cancel and lapse the options by notice to the participant. There's no strict Corporations Act requirements that have to be followed for that process.
Yeah, that is a very good question. And so, and on the tax side, for whatever reasons our politicians have decided is the correct policy position, a lot of the tax concessions are easier to access using options than shares, right? So for example, the startup concession, you're able to give a bigger discount when there's options compared to shares. When it comes to deferred taxation, employee share option schemes, once again, easier to do options instead of shares.
Yep, fantastic. Thanks, Jack. Okay, so I think that's all the time. We have all the questions kind of coming through for today. Certainly, if you have more specific questions, then please claim your complimentary consultation. Feel free to submit those questions in the survey at the end. If we weren't able to answer your question today, and to learn more about LegalVision's membership and how Jack and William Buck can assist you further as well. We also do have more resources had a lot of questions about employee options and shares and things. We have a lot of resources about those points available on our website as well if you do need any further support with that. And while this is a free webinar, we really do value and appreciate your feedback. So if you can, please complete that survey when it comes up at the end of the webinar, that would be fantastic. So thank you so much for joining us today. It's been wonderful to speak to you all today. We hope that you found this helpful, and we hope to speak with some of you soon and assist you further.
Thanks, Bianca, and thanks everyone. Feel free to reach out on LinkedIn or email me.